Are we solving delays by removing friction or by removing safeguards?
Losing that your company just because that some petition has been admitted for default of the payment of some loan is a very painful process.
What distinct purpose does a separate EIRP actually serve? Does it serve any purpose? Welcome to yet another edition of Understanding Corporate Law with Dr. U K Chaudhary. Over the last few weeks, you've benefited from his insights, his inputs, his comments. He's somebody who's doing this because he feels passionately about what's happening in the country, and he wants to give back by sharing his knowledge, insights, and suggestions on how to make corporate law better. In the last few episodes, we've looked at how has the IBC process panned out, what are the effective provision and statutes, what can be better. Today, we are going to discuss IBC's amendments. The Government of India, through the Ministry of Law and Justice, on 6th April 2026, brought in the amendments to the IBC, and we are going to discuss that. Let me bring in Dr. U K Chaudhary into the conversation. Thank you, Dr. Chaudhary, for talking to us at BW Legal World.
Thank you for inviting.
Pleasure is all mine. Dr. Chaudhary, the government has listened to you and other experts and has made changes in the IBC. First of all, what are the welcome changes and what can be better?
Yes, there are some good changes. For example, there are a number of clarifications issued which has come either pursuant to the decisions of the Honorable Supreme Court of India, bringing out some concepts in the implementation of the Insolvency and Bankruptcy Code 2016. Some of them are more issuing clarifications relating to the various doubts in the mind of the stakeholders, but there are certain things which are coming for the first time, and as and when we dive deep into the discussion, I will share with you my comments that on some of the concepts which are coming for the first time. For example, the group insolvency concept and the cross border insolvency thinking of the Government of India are extremely new and good steps in the right direction. But some of the amendments, for example, rewriting section 12A, rewriting a new chapter on the creditors initiated insolvency resolution process, making some of the changes for enforcing the timelines. This, to my mind, is not reaching anywhere. You are putting up again the same efforts which really are not working out in the practical sense. So, your efforts of the legislature giving more powers to the creditors and then implementing through the push where the judiciary is getting less and less balance to maintain between the creditors and the other stakeholders. To my mind, it is disturbing the equilibrium which is required in any democracy.
Mr. Chaudhary, with your nuanced and balanced viewpoint, you're welcoming some of the changes. Like you said, the group insolvency provision is a good provision because it solves duplication and it solves wastage of resources. But there are provisions that you've talked about are not likely to help the insolvency stakeholder. First, let me start by asking you, has IBC truly changed borrower behavior and credit culture in India, or are defaults still being treated as a strategic tool to take over companies?
No, see, certainly over a period of last 10 years, it has brought out a change in the mindset of the borrowers. At one point of time, there was a borrowing right, center and the left, but I am seeing it now that for last 10 years or so, one borrowing discipline has come into the borrowers. it has inculcated an habit that if not required, don't borrow, because the very impact of losing your company which you have built over a period of time, let us say for 1 year, 2 years, 10 years or even 30 years or 40 years, losing that your company just because that some petition has been admitted for default of the payment of some loan is a very painful process.
It has put some fear in the promoter.
And therefore, it has put a fear of recovery directly through the process of the resolution of debt. This has brought certain borrowing discipline in the trade and industry. Therefore, that is the one positive impact of this legislation, that there is a complete change of mindset in the borrowers. But it is also true that in that sense that you are putting a fear of borrowing. If the fear of borrowing spreads, then the trade and industry will come to a standstill, because no company can work without a borrowing.
Capital is
therefore a very fine balance is required to be maintained, that it should be good to recover whatever the banks are saying. It's your money and my money with the banks. Banks don't produce money, they are using the public money. But there should not be undue fear in the mind of the borrowers that tomorrow if something happens, he will completely lose his company or something which he has built with passion.
Brilliant. Now, this leads me to this question: is CIIRP a natural evolution of the creditor in control model, or does it risk replacing judicial oversight with creditor dominance?
See, that's where I differ with most of the thinkers on the insolvency. If you look at the creditors initiated insolvency all over the world, whether you talk of United States, you talk of Singapore, you talk of United Kingdom, the Anglo-Saxon jurisprudence that which we follow, there is not so much of creditors control on any bankruptcy as we have under our Insolvency and Bankruptcy Code 2016. It has gone to a complete extreme end, and that's where my disliking to the Insolvency and Bankruptcy Code emanates. I like a fine balance to be maintained. I want the control with the judicial process and not truncating the judicial process by any provision of law, even passed by the parliament.
So, you want the checks and balances to come into play?
Because the checks and balances are not in the society at random. They are a part of my constitution, and every democracy is governed by a constitution. In the constitution, the distribution of power has been equally divided between the legislature, executive and the judiciary. That is not being reflected in the IBC, that split is not reflected in this law. For last 10 years, we have been emphasizing again and again that give final power of adjudication to the National Company Law Tribunal, not to the creditors controlled COC. But for some reason, the interpretation of the IBC has led to give more and more and more powers to the Committee of Creditors, which is nothing but the banking institutions and financial controlled institutions by either the asset reconstruction companies or the non-banking finance companies, of course headed by the nationalized and non-nationalized banks.
You are saying that maybe we are not solving the delay by removing friction or by removing safeguards. Upside, maybe we'll come to the timelines thing, but you are saying that the checks and balances go awry with the new set of amendments. That's the point you are trying to make.
Yes, let me further explain that before I am misunderstood by most of the people. Like you take some small amendment made in section 7, section 9 and section 10. Honorable Supreme Court has already dealt with the timeline issue. They say timeline of 14 days, timeline of 30 days, timeline of 190 days, timeline of 330 days. This all is not mandatory. This is all is
Guidance.
is the kind of for the guidance, or it's what according to me is not mandatory or binding, correct. Now, once the Honorable Supreme Court has reached that legal finding and given those judgments, to now bring an amendment by way of adding a proviso saying that if the National Company Law Tribunal is not able to decide the petition, either accept or reject within a period of 14 days, then it must record reason in writing for doing so.
Sure, you said this before too.
And I have said it before that there are various kind of odd reasons. For example, there is no court available to the tribunal. The bench is sitting half a day. What does it write in the order? That I could not complete this process of 14 days because there was no bench available to me, because there was no courtroom. How will it reflect on the government? How it will reflect on the society? How it will reflect on the professionals like me? So, you are pushing a time limit which is completely, number one, impracticable, and then giving a burden of the discharge of that impracticable solution to a judicial body which is National Company Law Tribunal. This is what is not appreciable, particularly by me. Similarly, you have various timeline which has been already had that they are not mandatory. If it is so, then why this exercise again and again and again, insisting on the same thing? Why can't you be little more magnanimous and take a practical view that sorry, no judicial process can one way or the other terminate in 14 days. We have learned it for last 10 years, and we have not seen a single case, not even a single case, where adjudication process one way or the other has ended in 14 days. So, what is the point in giving this kind of responsibility to the National Company Law Tribunal members of the bench that give a reason if you are not able to do something in 14 days? This is not appreciable. This is not democracy.
Mr. Chaudhary, now basically the timeline changes that have been brought in, now there is a 30-day thing, there is a 150-day, right?
Yes.
Are these practical? Are these implementable? What are the, how do you see they being implemented?
See, we always possibly lost sight of one thing, that all courts are saying that the resolution process is not a process of recovery of money. If it is not a process of the recovery of money, and it is a process of establishing is there a debt and whether is there a default, but some adjudication in some cases have to go to the root of that matter, is there an existence of the debt. So, emphasizing that the debt is already there,
Establishing.
you are assuming that there is a debt, whereas in some cases this assumption may not be true. There may be a dispute on the debt itself, and this is in the first judgment of the Honorable Supreme Court in the innovative case. That is why that there is one fine line by the Honorable Judge, that the debt must be payable in fact and in law.
Right. So, are we solving delays by removing friction or by removing safeguards? For example, the stated upside for bringing in this is speed, early intervention, reduced tribunal burden. We've talked about the resources at hand, but the risk is larger in my view, which is creditor overreach, procedural unfairness, increased post facto litigation. What is your point?
Yes, I am in complete agreement with you, Dr. Batra, that if you rush things to that extent, it will have number of things which will be fatal in the whole judicial process. For example, there may be unfairness creeping into the system of adjudication. There may be a justice which may be hurried to an extent of being buried. There may be the stakeholders on one side, the banks may be very happy, but the other stakeholders may not be that happy. So, it is leading to a situation where instead of solving the problem, you are creating more problems. You are creating more problems for the bench, for the National Company Law Tribunal. You are creating more problems because it is a litigation. So, the people will go in more appeals, they will file more applications, they will be seeking more clarifications. So, this kind of an approach to push the whole system into a complete compressed, compressed situation of a resolution of the debt, according to me, is completely unfair.
So, clearly,
and therefore, somebody has to see this whole problem with an open mind, not with a closed mind. You can't first decide, I have to have the resolution done in 14 days and then make the law. No, you have to say, I have to have a resolution of the process, but how to achieve it in practical sense. That should be your open mind to make a legislation of this nature. And that is what I told you, that United States, there is not much of a creditor's control even today. Even in England, the jurisprudence which I follow in my country, the creditor's control is not final. When an administrator is appointed by the bankruptcy court, even that person is final only because that bankruptcy court is approving his or her actions. So, it is ultimately the court or the tribunal which has a final say in the matter. In no other jurisdiction, the bankers who have initiated the whole CIRP is controlling that CIRP. And I told you the ills of it, that you are almost converting an independent resolution professional as a person who is following the dictate of the COC.
Absolutely.
That is the one negative.
You have brought it out in the earlier podcast.
Such a tight control or a watertight control of the COC on the process.
Dr. Chaudhary, what you are in essence are saying is, these are complex disputes, there are nuanced issues, for example, wrong debt, inflated claims, no borrowing, they may not get examined in entry because of what is being brought in. That is the point you are trying to make. And let us move on from that. If insolvency under section 7 and 9 is already creditor driven, what distinct purpose does a separate CIRP actually serve? Does it serve any purpose?
According to me, except that you are short circuiting the whole process. Somewhere there is a thinking that even the process which is section 7, section 9, section 10 is not possibly to their liking, and therefore, they have decided to short circuit the whole process.
Right.
Now, it can have a spark which can burn the whole scenario. Therefore, according to me, there was already a creditor's control. Honorable Supreme Court has acknowledged it in various judgments, including I quoted number of judgments like G K Mishra and S R Steele, where they have already said that sorry, once a commercial decision is taken by the COC, it is not even justiciable. It becomes final. And until something is terribly found wrong with that commercial decision, meaning thereby that it violates patently some law, either IBC or any other law for the time being in force, then and then that commercial wisdom should be challenged or set aside by the NCLT, otherwise not. Now, once you have that kind of a tight control, I do not see what was the purpose of creating chapter 4A and calling it a creditors initiated insolvency resolution process, as if section 7 is not by creditors, as if section 9 is not by creditors. They are also financial creditors and operational creditors. So, to short circuit it from the creditor's petition, sending it to the 51%, which could be 1% or 2% or 3% put together, starting the whole process and then giving a burden on the corporate debtor, saying, now you challenge this process, I have initiated it. Now, this is, according to me, is short circuiting the whole adjudication process, and this is not to my liking. It may be to the liking of many people.
So, you are saying it may be counterproductive. In fact, let me just to build on this.
My take is that adversarial procedure, the violations of the principle of natural justice, it will lead to more litigation, and eventually you concede in that chapter that if at any stage the 66% of the creditors feel that no, this process is not correct, the process of section 7 and section 9 is correct, then this process can also be reverted back to the same process of section 7, chapter 2 and 3.
So, will pre-initiation notices, which is within 30 days, will they reduce disputes or simply shift litigation earlier and increase pre-admission challenges? What will happen in your view?
Let us see, Dr. Batra, the practical situation. If I am a banker, I have already made up my mind, one banker or two bankers with 51%. So, I have already made up my mind that I wanted to start the CIR process against such and such company which is notified in the rules. So, I have already target in my eyes. I have already decided. The 30 days representation period to that corporate debtor, the ill-fated company,
is a formality.
Is a formality.
It doesn't serve any purpose.
It doesn't serve any purpose. You will in any case start. So, you appoint a resolution professional. The resolution professional then give a public advertisement. The damage is done. Then comes even more, something which is not in consonance with the corporate law of the land. The board is supposed to be the apex body taking decisions in the interest of the company, not in their interest. That is what the corporate law is. Section 166 of the Companies Act. It says no director, whosoever he is, including a promoter director, cannot take any decision against the interest of the company. So, his duty as a director under section 166 is to think only and only about the interest of the company. But what this chapter says, that if such a decision is taken by the board, the resolution professional can veto that decision, and then it will be treated as abandoned and given up and not passed.
Then that will lead to a stalemate. Rather than solving things, it's creating a logjam.
Exactly. So, instead of resolving the problem of the company, you are creating a deadlock in the company. And I don't find any provision that if any decision of the board is vetoed, where they should go for the redressal of their grievance. So, they will find all kind of applications in the NCLT. So, first they will challenge the publication notice, then they will challenge that there is no default. Then if the decision comes against them, they will go in appeal. So, the matter will travel to the Honorable Supreme Court in chapter 4A also. I ask myself a question, what are we doing? It is an adversarial litigation in any case. If anybody target a company, the company's promoter are supposed to defend.
Sure, I see your point.
This IBC, according to me, was meant only and only for one situation, where the debt is admitted already, default is admitted already, there is no adversarial adjudication required.
So, right.
But we have converted the whole process by making various kind of provisions in the statute itself, that we have made it a litigation prone statutory recognition of the various adversarial litigation parties.
You are right, Dr. Chaudhary. So, by allowing creditors to initiate the process outside the NCLT, are we bypassing a critical judicial filter without solving the underlying delay problem?
According to me, yes. According to me, yes. Because as I said, that I firmly believe that in every enforcement of the law, the final say has to be with the judiciary. Because if there is a dispute, that dispute can be settled only in accordance with law, and the law can be interpreted and implemented only by the judiciary, not by the executive, not by the banks, not by the COC, not by the other stakeholders. Therefore, I always from the day one saying that final say in all IBC matters will be with the National Company Law Tribunal.
Dr. Chaudhary, let me ask you a direct question. Does compressing timelines and bringing in these amendments risk turning CIRP into a formality driven exercise where resolution plans are prepared for compliance rather than value maximization?
See, they are saying that as if the cutting on the timeline is maximizing valuation of the company. This is really not happening so. As I told you that once a company is a going concern, there is no question, I have earlier also said, there is no question of its valuation diminishing or retarding day by day. There is a mandate in the statute itself that every company until the debt resolution takes place must remain as a going concern. Only in the liquidation the time stand possibly rests the plant and machinery or rests its receivables, but not otherwise in any other sense. Therefore, to say that let us cut down the time period is only that you are disturbing that equilibrium, that fine balance which is required to be maintained in any adjudication process. Every adjudicatory process must have that fine balance between the stakeholders, principle of natural justice to be determined by a court of law.
Right. So, what is the in your view, because you for 5 decades practiced in this arena like a gladiator, you are very well known in the company law board earlier and now the NCLT, NCLAT. What is the underlying policy objective in your understanding behind introducing chapter 4A, which is it efficiency, is it creditor empowerment, or is it systematic bypass of institutional delays?
Frankly, the more I read that chapter, I am not able to decode the reasons of that chapter. But I am sure that somewhere some process has triggered this kind of thinking, that bypass the National Company Law Tribunal, trigger the whole process, target the company, and then let it be acquired come whatever may. Now, according to me, this is a forceful acquisition, this is a hostile acquisition. This hostile acquisition was not even permitted under the Securities Exchange Board of India rules.
Mr. Chaudhary, given you talked about the existing capacity constraints in the past conversations, which is RPs, information flow, litigation, is the ecosystem as it exists today realistically equipped to deliver a credible resolution within 150 days?
I don't think so. That is why you see that most of the best cases which have been solved, for example, I will give you one burning example, SR Steel. How many days it has taken? It was completed the whole process ultimately more than 4 years. And ultimately the Honorable Supreme Court has to exercise its powers under Article 142, that in the interest of the justice we pass this order. So, it is under the special powers, not under the IBC timeline, that the matter got resolved. Therefore, to rush things like this is not my cup of tea, and that is why that possibly not many people like my discussion on these timelines. That is the reason that I am saying please maintain the equilibrium in the system. don't destroy this ecosystem which has worked so well up to now by making an amendment which according to me are completely counterproductive and meaningless. I am saying it with responsibility that chapter like 4 is meaningless. It will lead to more litigation rather than solving the issues. So, don't destroy this legislation which has for the first time produced results, whereby you have reduced your NPAs from 18.5 lakh crore to 0.5% today.
Absolutely. So, something they say don't fix something that ain't broke, it's working.
Yeah. So, you are stretching the elastic to such an extent that the whole ecosystem will break, and then it will be very difficult for you to fix.
Okay, let me ask you another question. Now, a real estate company is very different than a financial services company. A financial services company is very different than a manufacturing company. Do we need sectoral nuanced amendments?
Yeah, that amendment has also come in this amendment also, that now for example, that even before the amendment came in the IBC, there was already an active judicial thinking that in a real estate which requires a different thinking of the insolvency resolution process, we were going project wise. There are number of decisions of the National Company Law Tribunal Appellate Authority which has already taken the view that sorry, you can't put the entire projects of a real estate company into the hands of the IRP if there is no default in the other projects. So, why the home buyer should suffer? Of the projects which have already completed, occupied by the home buyers, why they should go to the resolution professional only because there is a default in some other project? That has now got the statutory recognition, that in real estate it is possible to have a project wise resolution, and in fact it should be only project wise resolution. So, that kind of thinking which is already in the judiciary, which is already good with the stakeholders, these kind of amendments I can understand clarificatory in nature, but a right welcome in the correct direction.
And Mr. Chaudhary, you did upfront welcome the fact that in the chapter 5, you are talking of group insolvency.
Yes.
That is likely to save procedural delays, costs, and not put that much.
And meaningful.
Yes, it's meaningful.
It's purposeful and meaningful.
It will not put that much pressure on the already stretched apparatus for IBC.
Exactly.
Now, let me ask you, Dr. Chaudhary, hearing what you are saying and knowing your understanding of this domain, does the new framework and the amendments increase the risk of insolvency being used as a pressure tactic or acquisition strategy rather than a genuine resolution mechanism?
It is already, in my opinion, is acting as a pressure tactics. Otherwise, despite our saying so, if one purpose, one meaningful amendment which has not yet come in the IBC is what has happened to the Companies Act 2013. There is section in the Companies Act 2013 that in any litigation before the National Company Law Tribunal, if either party make an application to the National Company Law Tribunal that this issue requires a mediation for sorting out, then the parties are mandatorily to be sent for a mediation. I ask myself a question, and I ask others also, the stakeholders, what is wrong? Even if that 30 days notice under chapter 4 is to be given the intention to initiate so-called creditors initiated insolvency resolution process, which in my opinion section 7 already is. Why can't you would have said that during that 30 days not only the representation, but let there be a mediation. Maybe you will reach a resolution of the debt or the resolution of the problem within that 30 days by mediation instead of going to the resolution professional. But nobody in my mind is thinking on the lines that sometime a discussion and a mediation is the best process to resolve the issue. not within the family, but including the nations. Independent sovereign nations also, if sit on the mediation, they can find out the problems for their solution.
Ultimately, that is the solution. We can see in the context of what we are talking in the background.
What is happening in the world?
We are boiling
Correct.
down to that.
Therefore, pressure tactics work to a certain extent. Then people take a hard stance. That is why that you need the expert mediators. You required expert mediators to persuade the parties to find out a resolution. And I am not saying that the IBC is not there, but why in the IBC there is never a provision for the mediation? On the contrary, Section 12A is amended. Earlier, the Honorable Supreme Court says that between the admission of the petition and the constitution of the COC, the resolution can take place, the settlement can take place, you can pay off the amount asked for in form number 1 by the bank and settle the whole matter, the petition will be dismissed. But now the 12A has been amended. Somebody says, sorry, until the COC is constituted, there should not be any settlement.
No, if the whole purpose is a settlement and the company.
The whole purpose was the resolution of the debt.
If it is resolved,
Person
then
is
where
paying
is the
the
issue?
debt. You are saying no, sorry, you can't. You have made a statutory prohibition. 12A has been amended. Now, this kind of a hard thinking on the part of the legislature to back up the banking institutions or the financial institutions, you are heading into a direction of putting more and more pressure on the trade and industry. You are doing the same mistake with the trade and industry what you are doing with the farmers and the agriculturist. No money can buy food if there is no food at all. So, if there is no manufacturer of the goods, no bank will ever lend money to anybody. So, you will doing more discredit to the banks by scaring away the borrowers. Please see the earlier repercussion. If nobody borrows money from the banks, what will happen to the banks?
Yeah, capital is a growth deliverer.
It
if
will
the
be
capital
completely
rise up,
stagnated. The entire banking sector will stagnate. So, don't scare the borrowers to that extent that at any whims and fancies of the banks, my company can be snatched away from me. Don't create that scare.
So, Mr. Chaudhary, you put a very convincing argument about some of the things that have been brought in. In your wisdom and your professional practice in this domain, what should have been the real amendments? What is still there that needs to be done apart from correcting some of the amendments?
I have said it at number of forums lately, even for an IPA institute, that number one, for God's sake, strengthen the National Company Law Tribunal.
In terms of the strength,
we were supposed to have 63 members only to deal with the company law problems. We have at least 4 times more petitions under the IBC than the Companies Act. So, if you say that 60 multiplied by 4 makes it 240. If we are not having 240, at least give us 100 members, give us 120 members, give us 150 members, so that the all benches could sit full time from 10:30 to 4:30, so that there are not more than 10 to 12 cases before every bench, so that they can meaningfully, purposefully deal with the cases by rendering true justice to all the stakeholders. This is not happening. There are no courts, you are not improving the infrastructure. All Supreme Court judgments, both Supreme Court judgments rather, say that the status of the National Company Law Tribunal has to be equivalent to the High Court of the state. This is not happening. We do not have a supporting staff. So, this is what is happening in the institution. You wanted the things to decide in 14 days. So, my first suggestion is, please improve the working conditions of the National Company Law Tribunal. First thing first, always have a long term plan that why it should not always have 150 members ready.
Capacity building is very
Capacity building. Then they must have the infrastructure, then the manpower, and enough budgeting. Imagine that if intervention of all the stakeholders have brought down from 18.5 lakh crores to a situation of only 0.5% NPAs, does such an institution not require a recognition in the eyes of the government that you fund it properly, man it properly, and give a adequate infrastructure? So, that is the first condition. Second is make timelines more practical. Don't pressurize them for 14 days. Give them 6 months time. Instead of saying 14 days, say 6 months. In any case, you are not achieving anything less than 6 months. So, what is the point in cutting 6 months to 14 days? You will never able to achieve it. So, why we are blindfolding ourselves? This is not, this is what I am saying. The second situation, take a practical view of the existing circumstances, which you are not taking. You means that neither the legislature nor the executive, and NCLT's powers should be, according to me, restored back. Final say must be with the adjudicating authority, not with the administrative authorities. Now, if we take these kind of practical suggestions, then possibly you will maintain the equilibrium. We require the banks, we require the borrowers, we require the trade and industry, we require the country to progress.
And we also need to
and please please see this, that we require a positive thinking, a practical thinking in this country, because we are already growing fastest in the world. If we have to continue this trend, then I beseech everybody that who loves democracy, that let us continue the trend of growing the fastest in the world. And we are capable of doing it. I am very confident that we are capable of doing it.
Mr. Chaudhary, I am sure the BW Business World viewers and the BW Legal World viewers and the stakeholders of this growth, which is the policymakers, the government, the Ministry of Law and Justice, the judicial ecosystem, the business owners, the banks, the professionals that are involved in insolvency. I am sure all of them would agree with your viewpoint, because you are making this nuanced viewpoint for the betterment of the implementation of the IBC, which has done wonders. So, with more resources and more nuanced changes, which are more practical and implementable, and ultimately build in checks and balances that the NCLT and the NCLT can administer, will benefit the whole ecosystem. I am sure all of our viewers and our readers will agree with that. Thank you for talking to BW Business World and BW Legal World. I hope your inputs are welcome and are taken in the right earnest of improving the IBC process. The government has been very proactive with bringing the amendments, and I am sure your views are valued and appreciated, and hopefully some of the things that you are saying are implemented. We will see how the amendments pan out when they are put into practice, and I hope the things you are saying do not happen. I am an eternal optimist, but I also see the merit in what you are saying, and some of the things that you have said in all our conversations, that continuous thread of making sure that the right lessons are learnt from the success of IBC, and wherever there is a opportunity to improve, nuanced point of view be factored in. I hope what you shared with our viewers is factored in and is of some value to stakeholders.
Thank you. I am hopeful too.
Thank you, Dr. Chaudhary. Till we talk another time.
Thank you.
I look forward to see you soon for our fortnightly conversations, and make sure that we go beyond IBC this time. All the best. Keep watching. This is Dr. Annurag Batra signing off BW Legal World, Understanding Corporate Law with Dr. U K Chaudhary. I'm sure what we've discussed today is contextual in the context of the amendments to the IBC on 6th April, and I'm sure you'll find Dr. Chaudhary's views deep, honest, and for the betterment of this initiative which has really helped the country in the last decade. Thank you. God bless you.
Thank you. Thank you.